Before we get started, I have 3 warnings. This is not a substitute for legal, investment, or tax advice. You need to consult with your own advisors as to what's best for your particular situation. There's just so many exceptions to the rules here in Medicaid that, just because one of your neighbors was able to get on Medicaid, each particular situation is different. Secondly, the main purpose here is to motivate you to plan, dispel myths, and make sure your wishes are carried out. And since we have so much material to cover, I'm going to have to hold questions till the end. I'll be able to answer questions at the end, either in public or I can stay after if you have any additional questions. How many people here want to go to a nursing home? You usually don't get too many yeses for that. So people say they never want to go to a nursing home, but they will never ever let their relatives go into a nursing home. But unfortunately, things can go downhill very quickly. Someone breaks their hip, they go into a hospital, then they go to rehab, and then they have to end up going for long-term care. So we never know what's going to happen. We have to plan for different eventualities. So the main overlying theme, though, is regarding qualifying for Medicaid. Medicaid is based on your resources. You have to be impoverished. It's the source of nursing home care, assisted living, and in-home care when you have no other resources available. You have to be impoverished. So the main theme is that you have to weigh it against. Many people want to save their home for their relatives or their assets for their relatives. But the underlying fact that you have to remember is that if you want to get into a good nursing home, and even the 5-star nursing homes are not that great, if you don't want to end up in a 1-star nursing home about 50 miles from here, and usually there's a very short time span to find a nursing home when you're being released from, or find somewhere even for rehabilitation when you're being released from the hospital, is that if you've made gifts in the past 5 years, or if you don't have at least $100,000 in assets, they're going to say beds are not available. They're not really allowed to discriminate against Medicaid patients, but they're only getting $250 a day from Medicaid versus how much is nursing home care a day? How much does a nursing home cost for every particular day? Does anyone know?
$12,000 a month.
It's more than that. It's about $500 a day now and keeps going up. So that's about $15,000 a month. So how do you pay for nursing home care? You have to pay from your income, your pension, your investment income. You may have to sell your home. Some of you may have long-term care insurance. Medicare only covers the first, if you've been in a hospital for at least 3 days, Medicare will cover in full for 20 days, and then it's a copay for the next 80 days. You may have a VA pension to pay for that. And if you don't have any of these assets or resources or income, then as a last resort, if you're impoverished, then you may qualify for Medicaid. So this is a rather bizarre system. Many people have a tough time understanding it, but to be eligible for Medicaid for long-term care, you can only have so much in income and so much in resources. So they look at your income and they look at your resources. Your IRA, for instance, if it's in a payout status, we'll talk about that, is not a resource, but the required minimum distribution, the required distributions are income, which would go to the nursing home, but the IRA in most cases will be protected, will not be considered a resource. So as far as income, you can only keep the first $50 in income if you're in a nursing home, or for in-home care, $934 per month you can keep. So, and New York's a little bit more liberal than other states. In other states, if you have a certain amount of income, you're completely disqualified from Medicaid. But in New York State, anything over and above these limits has to go to the nursing home or to or for your in-home care. So, like I said, you have to be impoverished, so you can only have $15,900 in resources. There's many exceptions to this, but that's basically to qualify for Medicaid. These are the income and resource levels. And we'll talk about many exceptions to this, about things that you and your family members can keep. So many of you heard about the look-back period. And that's 5 years. When you apply for apply for nursing home care, you have to provide records going back 5 years, all your banking records, and they will look for any gifts that were made in the past 5 years. Now, effective October 1st of this year, there will be a look back for in-home or community Medicaid also for the very first time. For the very first time, they will look at any gifts that you made. This law was delayed 2 years, but October 1st of this year, there will be a look back for if you're applying for community Medicaid for aides in your home. So if you want to make any transfers, you should be making transfers now before that law goes into effect. And it's going to be, they're going to look back, the look back period for in-home care is 30 months, and it's going to eventually be 5 years. Something to keep in mind. So what does a 5-year look-back period mean, and what's the consequences of that? Well, you are penalized if you've transferred certain assets within the past 5 years. If you're penalized, then it means you have to private pay for a certain period of time. So currently, the way they'll calculate the penalty period is in 2022, they're saying, which is really below what it actually is, but the rate for Western New York, and there's 9 different rates across the state, but what they say, they determine the penalty by the average cost of nursing home care, which they say for Western New York is $11,884, which is really less than what it is. So if you've made gifts, for instance, make it round figures, if you've made gifts of $118,000 over the past 5 years, you will be penalized 10 months, which means you need to private pay your nursing home for 10 months. So if you've given away money in the past 5 years or given away property for less than the full value, so if you sell your home to your daughter for $1, that's considered a gift because you're not getting back consideration for that. So if you've given away, say for instance, you gave your house to your daughter, and it's worth $118,000. You've done that in the past 5 years. You will be penalized 10 months in which you will not be qualified for Medicaid for 10 months until you've private paid for 10 months. So, for one thing, so any transfers made for the purposes of qualifying for Medicaid, you'll be penalized for that. Now that's just a presumption. You have a right to challenge that, even if you've made gifts in the past 5 years. If you were in excellent health 4 years ago when you made this, you can ask for a hearing on that. So I would encourage you to have regular medical checkups to show that you are healthy at the time you're making these gifts, so you can fight that presumption. But it's presumed, and there's exceptions, like I said, it's presumed if you've made gifts over the past 5 years, those were for the purpose of qualifying for Medicaid, but if you're in good health, you can ask for a hearing on that. So, basically when they look at your banking records when you apply for Medicaid, you have to provide banking records for the past 5 years. And this varies from place to place, but usually withdrawals of less than $1,000, they will not ask you for documentation. And that varies from county to county. But anyway, for the most part, transfers of $1,000 or more, they're going to ask you where that money went. Now, one misunderstanding is many of you heard you can make gifts of $16,000 per year. It used to be 15, and before that it was 10,000. Well, that has nothing to do with Medicaid. That's the U.S. estate and gift tax exemption. That, in addition, you can give away during your lifetime or through your will $12 million, and you're exempt from U.S. estate tax, and from New York estate tax. New York doesn't have an inheritance tax, but New York estate tax of $6.1 million right now. So you know, that may change. So in addition to the only the U.S. government has a gift tax. New York no longer has a gift tax. But so in addition to giving away $12 million, you can give away $16,000 per year to as many people as you want, and you don't have to file a gift tax return. And it's not taxable to the people that's receiving it. So that only applies to estate and gift taxes. Okay, they also looked at past patterns of where you've given gifts to family members for birthdays and so forth. Okay, so if your spouse is in a nursing home, there's certain assets that you can keep. They want to make sure that you still have enough to live on. So if there's still a spouse at home, then if you're in a nursing home, your spouse can keep $137,400 in assets for themselves, and income of at least $3,435 combined income. And you will still qualify for Medicaid. So in addition to that, if you're in a nursing home, even if your spouse has $1 million, they can refuse to support you by signing a spousal refusal, and you will still qualify for Medicaid. So how that works is that if you signed a spousal refusal, then the county, if your spouse is in a nursing home and you sign a spousal refusal, the county can still come after you in family court to collect what's being paid for Medicaid to your husband or wife. But that would be at the Medicaid rate, not at the full private pay rate. So it's something that you talk to your legal advisors about what the pros and cons of doing that. Okay. So one thing you might want to do if your spouse is in a nursing home is to revise your will, to disinherit them, because you never know who's going to die first. You at home could die before your spouse in a nursing home, and you don't want everything going to your spouse and in turn go to the nursing home. So there again, basically you can't disinherit your spouse. And if you do disinherit your spouse has a right to file what's called a right of election, which means that they can file against your estate to get at least $50,000 or 1/3 of your estate. So how that works is if you were to disinherit your spouse that's in a nursing home and you die first, the county attorney's office would file a right of election on behalf of your spouse to get what he or she's entitled to, at least $50,000 to 1/3, but at least the remainder of your estate could go to where you want it to go to your children and so forth. So it's still advisable to disinherit your spouse if he or she is in a nursing home. So we talked about this quite a bit in detail on Tuesday about non-probate assets and about how they cannot file claims for Medicaid against someone who has non-probate assets. They can only file a claim against what someone in a nursing home has left in their will. And as we discussed in detail on Tuesday, non-probate assets would be life insurance if you have beneficiaries on that. IRAs if you have your beneficiaries up to date on that. Annuities, for instance. certain payable on death bank accounts. There's one automobile that can be left with up to $25,000. Living trusts and investment accounts that are payable on death. So if you learn one thing from this presentation, that should be that you need to have a power of attorney with gifting powers. Okay? So that could be your most valuable, that can be the most valuable tool, especially if you never planned for Medicaid to preserve your assets. So powers of attorney are valid until you pass away. They automatically are terminated upon your death, or if you can revoke them during your lifetime. They can be immediate or springing. So they could be immediate. They can go into effect right away when you and your agent signed. Or they can be springing. Probably about 1% of our clients are a little paranoid and they don't want their powers of attorney to go into effect immediately. So you can specify that it'll go into effect when a doctor certifies that you are incapacitated. So your power of attorney with a letter from your doctor saying that you're incapacitated will put the power of attorney into effect. So there's been changes in the power of attorney format over the years. Even if you have a very old power of attorney, it may still be effective. But in 2009, they drastically changed the power of attorney forms to require the agents also to sign and require witnesses. They made somewhat of a modification in 2010. And then this past June, they made another major change in the powers of attorney documents. The 2009-2010 powers of attorney involved 2 different documents, a power of attorney and a gift writer, and that got a little confusing. And there were people were having problems with banks accepting the powers of attorney. So one of the changes but this one change with the law applies to all powers of attorney, even those before 2013. There's a whole procedure set up that banks have a certain period of time now to approve powers of attorney or not when you bring them in for your bank accounts. Banks have gotten paranoid about powers of attorney with sometimes the agents don't really have the authority that they say they have, or they may have been revoked. So sometimes banks like to spend, because they can be held liable for releasing money to unauthorized people, that sometimes they go through a very rigorous process of making sure the powers of attorney are available. But anyway, any powers of attorney that you executed prior to that are still valid, but you may still want to have your powers of attorney reviewed. So these powers of attorney, we got these. Powers of attorney, you should have your powers of attorney reviewed by your legal advisor. So one of the important changes in 2009 was adding a rider if you wanted to be able to make unlimited gifts in 2013. So I do strongly recommend that you have, we did this before the law was changed in 2009, but because the old powers of attorney that used to be 1 page, now they're about 10 pages long, but the old powers of attorney from before 2009 limited gifts to $10,000 per year, which used to be the reason for that used to be the annual gift tax exemption. So those are useless as far as Medicaid planning. We're going to talk about emergency Medicaid planning at the very end, but we'll see a few instances here why you really need to have gifting powers in your power of attorney document to do pre-planning and also emergency planning for Medicaid. Otherwise, your agents will be limited as far as preserving your assets to carry out your wishes. So we have many instances where people don't have those gifting powers in their powers of attorney, so the agents are limited as to what they can do to preserve someone's assets. In those instances, we have to do what's called Mental Hygiene Article 81 guardianships. This law was revised about 30 years ago, the guardianship law. Those are for incapacitated people. And the law is very flexible. It's a very low burden of proof to have someone declared to be incapacitated. It could be that they're not making wise decisions either for their personal well-being or their financial. So it's a very flexible law, and they say want to impose the least restrictive means of protecting people. So we've done this many times. We've had guardians appointed primarily to do this, what we're going to be talking about, this emergency gift, emergency Medicaid planning at the very end, and which is been authorized by judges to make gifts at the very last minute, where people will still qualify for Medicaid, but gifts can be made. If they're not able to express it, it may go according to what their will says about who they intended to preserve their assets for. So even with a power of attorney, sometimes we have to go through these guardianship proceedings that are known as guardianships for incapacitated people. And medical proof is not necessary for this. Usually it's proof of people's observations of why things that people are doing, either being taken advantage by other people, or they have no idea of how to manage their money, or they need assistance with daily living and personal hygiene and so forth. So that is the other alternative. So and all the standard New York State, there's a certain format that has to be used for powers of attorney, especially the ones before 2013. You couldn't vary at all from what they call a statutory form. They're durable. And what does durable mean? That means even if you later become incapacitated, they're still valid. And also the laws since 2009 require if a guardian is appointed for an incapacitated person, that the power of attorney has to provide a complete accounting to that guardian. Also, something to keep in mind is that the responsibilities of powers of attorney, and we come across this quite often, that there's been someone's power of attorney for their father or mother, and they've been doing a lot of self-dealing and abusing that power of attorney by taking their parents' money or obtaining credit cards and that. Even after death, any family member can demand an accounting from the power of attorney as to what the activities, money that was paid out, and provide receipts for any expenditures that were made. So those are the responsibilities of the powers of attorney. To account to guardians and also to account to family members. And that's one of the reasons that agents were required to sign the powers of attorney beginning in 2009 so that they are accepting that responsibilities. They have what's called fiduciary responsibilities, and that they understand that they have fiduciary responsibilities, which is having the same responsibilities as a trustee of a trust or a executor of an estate, to do what's best for the estate or the trust. So that's why agents have to sign. The powers of attorney do not go into effect until you sign it and your agent sign it. There's also, we have HIPAA authorizations in the powers of attorney, so you can get those protected medical information. So in order for a power of attorney to be able to, your power of attorney to talk to your doctors and hospitals and medical providers, they have to have a HIPAA authorization to even discuss billing, either in the power of attorney or in the healthcare proxy. And also, the newer powers of attorney require third parties to accept it and not require their own forms, because banks used to require that their own power of attorney forms be completed, but banks are required to accept this form. They cannot require you to use their form of power of attorney. The only agency that doesn't accept powers of attorney are the VA. which is surprising, but I guess the VA can do whatever they want, so they will not accept they will not accept the power of attorney. But other than that, all financial institutions, and you can designate in your power of attorney what financial matters you want your agent to be taking care of for you. And you're not giving up, you still can make your own decisions by signing a power of attorney. You still have the freedom. The power of attorney can't do anything against your wishes. The only one that can really do anything against your wishes would be a court order. So you still have that freedom to do what you want. Anyone here have long-term care insurance? Does anyone have your partnership plans? Okay. So I'm not an expert on long-term care insurance. I can refer you to some people that are. Just like to mention it, there's fewer and fewer companies that are offering long-term care insurance, and the rates keep going up. I do recommend it. It does cover assisted living. It does cover in-home care. It does cover skilled nursing care, and you may want to get it while your health is good enough so you can qualify for it. There's traditional plans. The New York Partnership plans are that they provide coverage, and when the coverage period runs out in 3 years or whatever, with a New York Partnership plan, you automatically qualify for Medicaid regardless of how much you have. So even if you have millions of dollars and you go beyond the coverage period of 3 years or whatever, you will qualify for Medicaid, but you will still have to pay over your income to the nursing home. There's also hybrid plans, that a combination of long-term care insurance and life insurance. How many people have transferred their home to their children using a life estate deed? A few of those, okay. So if you transfer your home if you sign a deed and transfer your home to your children and you keep life use, you're still entitled to your property tax exemptions. You do need to reapply for them before March 1st of the date that you sign over the property. You still will qualify for your STAR exemption and so forth as long as you're living in the house. The house gets the stepped up capital gains treatment, which means that even though you only paid $42,000 for your house back in 1965, even though it's worth $300,000 when you pass away and your children sell it for $300,000, they don't have to pay capital gains on that. They get the stepped up cost basis. It's a non-probate asset. It will not pass through your estate. Medicaid can't get a lien against it. So for a very short time, about 11 months, back about 10 years ago, they were able to recover against life estates, estate recovery. Like other states do have estate recovery against non-probate assets, but New York State does not. And that's something I'll think about in all your planning, that there's no Medicaid liens against non-probate assets. And if you sell your house, so say you you transferred your house 5 years ago and you're going into a nursing home now, it's not considered a resource. But if you sell that house, then some of the sale proceeds of the house will have to go to the nursing home. If you sell it, you don't have to sell it, but if you do sell it. So if you're 80 years old, this changes every month, but based on the IRS life expectancy tables, if you transferred your house and you have just life use, there's a certain value assigned to that. And if you're 80 years old, about 15% of those proceeds you're entitled to, whether you take it or not. So about 15%, if it's a $300,000 house, it'd be about $45,000 would have to go to the nursing home. There's a couple of disadvantages to the life estate deed. If your children go bankrupt, a certain amount of money would have to be paid to the bankruptcy court. So, for instance, if you are 80 years old, there could be as much as 85% of the value of the house would be paid to the bankruptcy court trustee, because that's the value if you just have one child that has the interest in the house, what they call remainder interest. If you have one child, their interest is valued at 85% of the value of your house. And I've seen it happen before. In fact, the child did not list the house on their bankruptcy petition, and they had to go back and reopen the bankruptcy case and get the records from New Jersey where they're stored. Another disadvantage is if your child sued, there would be judgment liens against the house. So when someone's sued, there's a general judgment lien against any real estate that they own in that county. So with a life estate deed, if you transfer and keep life use, you have a life interest in real estate. Unlike other types of assets, there's another level of ownership. Your son or daughter would have ownership upon your death. They call that remainder interest. They don't have the right to occupy the house, but immediately upon your death, they have that interest. There's ways of eliminating those problems, which we'll talk about in a moment. Another option to protect your house, and this is very rarely done because the numbers just don't work out, but you purchase a life estate interest in another person's home or in a new home. So you sell your house, and then you use that money to buy another house with your children, or you give the money to your children to add an addition onto the house where you can live there. So that a lot of times the numbers don't really work out as far as being able to protect that, but that's an option. As long as you're living there for a year, then the home would be protected. There's also protection for your primary home. There's an exemption of $955,000 equity exemption, which covers most homes in this area. Downstate, it doesn't cover most homes, but equity exemption would be the difference between what your house is worth and the mortgage. Whatever the difference there would be your equity exemption that your primary residence is exempt. So that is, even if you're single, you get that exemption. So you would originally qualify for Medicaid, but if you're in a nursing home for 6 months or more, it's assumed that you're not returning home. So if you're single, you would no longer have that exemption, and the house would have to be sold. There's an exemption. Your primary residence can be, like I said, yourself, your spouse. Now, all these penalties and everything, there's no limit on what you can transfer to your spouse. There's no look-back period or penalty or whatever, excuse me, we can transfer your spouse. So, but the issue again is if you're incapacitated, how are you going to transfer your house into your spouse's name? And you want to do that because for the exemption, and also if your spouse passes away before you and you own the house as husband and wife, it's automatically going to be transferred to you. So here again, that's where you need the power of attorney with a gift rider to be able to transfer the house to the well spouse to protect it. Also, your house is protected if there's, you can make transfers if you have into trust for your minor, disabled, or blind children. It can be transfer the house to them to protect the house. Another protection for the house is a sibling with an equity interest. So they don't have to be on the deed, but if your brother or sister's been residing with you for the past year, helping out with the expenses, you can transfer that. If you go into a nursing home, you can transfer your house to your brother or your sister, and there's no look-back period or penalty for that. That's an exemption. Like I said, there's many exceptions to many of these rules, and that's one. So that's really when we do consult with people, we need to know the whole family dynamics to see what assets can be protected, even if no one's ever done any planning. There's another exemption which happens quite a bit, and that's a caregiver child that's been residing for the past 2 years with the person. Usually they've been residing there for the past 50 years. They never left home. There's many children like that. But if they've been living there for at least 2 years before you go into nursing home, you can transfer the house to them. There's no penalty for doing that. That can be done. There again, if you're incapacitated mentally or physically, how is that going to be accomplished? It's going to be accomplished by your power of attorney if they do have those gifting powers in the document, or it's going to have to be done through a guardianship proceeding. So we can commence these guardianship proceedings, cause a little bit of a delay. Guardianship proceedings on average can be done. You're done with the Supreme Court, Erie County Supreme Court here. It's going to take at least 2 months to get that guardian appointed. Maybe a temporary guardian can be appointed also for an incapacitated person, but there will be delay, and you want to move things as quickly as possible with your Medicaid application. Who's going to complete the Medicaid application if you don't have a power of attorney? Then a guardian is going to have to be appointed. So there again, a power of attorney can be very valuable, even without a gifting powers, for someone to complete a Medicaid application on your behalf. It's difficult enough for people that have capacity to complete a Medicaid application, let alone people that have difficulty in gathering all this information and completing the application. So, number 7, any people here who have living trusts? I covered this on Tuesday also. So you can, it's all a matter of control. So you can, like I said on Tuesday, you can give away property if you want to preserve your assets or avoid probate. You can outright give away property. Or, I mean, the other alternative is that if you want to have management of those assets, if you want to protect it from nursing home costs, it would have to be an irrevocable living trust. So there's revocable and there's irrevocable living trusts, and it has to be irrevocable to protect your assets. And say you're with a 5-year look-back period, you would have to have funded the trust. Most people are using irrevocable trust instead of a life estate deed mainly for their principal residence. There's an advantage over a life estate deed because if your children go bankrupt, it doesn't affect it. It doesn't affect the house at all if it's an irrevocable trust. If they're sued, it doesn't affect the house at all if it's an irrevocable trust. If you decide that you're sick of these winters and you want to move to Florida, your trustees can sell your house and buy you a house down in Florida. You don't have to start all over again with a 5-year look-back period. Or if you do sell the house with that instance like where you're beyond the 5-year period, nothing at all is going to go to the nursing home because all the sale proceeds will go to the living trust. So a living trust is an agreement. You place your assets in the control of trustees, which would have to be other than yourselves, and you're limited. You can't access the principal in the trust, except you will be allowed to live in the house, so you'll still get your property tax exemptions. And then it'd be like a will. It'll provide what's going to happen to your house when both you and your spouse pass away. It can be distributed like in your will without going through probate, distributing the proceeds from the sale of the house according to what your wishes are in your living trust. So that's an alternative. Living trust, let's look at the pros and cons of that. Some people get revocable trust just for the purposes of avoiding probate, but to preserve their assets, it would have to be irrevocable. As I said, the creditors of your children will not have any bearing if your house is in. If they're sued or go bankrupt, will not have any bearing on the trust. So what we have done sometimes to avoid the bankruptcy issue and judgment issue with people using just a life estate deed is to deed it with a child that's least likely to go bankrupt or be sued, and then that child signs an affidavit. They will share the proceeds of the house upon the death of the life tenant. With their siblings. They do not consider prepaid funeral accounts are not considered an asset of yours when they consider your $15,900 in resources. So you can set up a prepaid funeral home that's done completely through a funeral director, makes a deposit there. I wish I could say your money's completely safe there, but there have been a couple funeral directors in the Western New York area who have misappropriated those funds. But I think if you're with a reputable funeral home, your funds are for the most part protected. But both, those funeral directors were prosecuted criminally, but these poor people did lose their prepaid, and their families lost the funds. So just a little bit of a warning. It doesn't happen too often, but if you go with a large entity, a trustworthy entity, you should be okay. IRAs, this is something you're planning also. If IRAs, if they're on payout status, they're not considered to be resources. Only the distributions are considered to be resources, IRAs and 401ks. So it's something to think about when you're spending down. For instance, if you're paying for in-home care and you don't want to use an agency, if you want to use private aids. Unfortunately, we've seen a couple instances where these home health care agencies, they do hire felons. There was a case where was usually be prosecuted, but the home health care aide who already had a pending criminal case against him was hired by a home health care agency. We're handling the estate of the person, but he stole about $90,000 in cash from a safe. They prosecuted him for $50,000, and the only reason they were able to prosecute him was because he was stupid enough to post on Facebook the things he was purchasing with the $50,000. But that's very unusual to be able to prosecute the Erie County Sheriff's Department did a good job on prosecuting it, and the Erie County District Attorney's Office, they were only able to prove 50 of the 90,000. But yeah, I know for a fact that they do hire convicted felons. I mean, that's my personal preference would be privately placed home health care aides that come from recommendations from other people that you know. They're put in a position of having great control over people's finances, unfortunately. Many people do keep cash in their home, and they still don't trust banks. So that's something, ask for recommendations from people that you know for home health care aides. Medicaid won't cover it, but Medicaid has limited coverage for home health care aides. So that's just my opinion. But so anyway, when you're looking at what assets if you're going to be paying for home health care aides yourself, you're looking at what assets to spend first. Don't spend your IRA funds first. Spend your other funds, because if the person does end up in a nursing home, then the IRA money will be protected. There's also the IRS recently passed a law, and there again you need to talk to your investment advisors about this, about these qualified longevity annuity contracts, which you can limit the distributions that have to be made, the required distributions from your IRA, so it'd be less that would have to be paid to the nursing home. So your daughter's been taking care of you, helping you with finances, and they're 24 hours a day caring for you, and you want to reimburse her for the past year. So if you pay her now, is that considered to be a gift? Would that be ruled as a transfer gift? Yes, unfortunately it will. The only way you can pay for family caregivers would be through a caregiver agreement. And there's some disadvantages to that. It does avoid family disputes. It has to specifically define what the duties of the caregiver are for your financial matters. And you can pay a reasonable pay in advance for a year to define those duties. The only disadvantage of that is, first of all, Department of Social Services has said many times they hate these agreements. So they will really scrutinize these agreements, and you have to be sure that they're prepared properly. They should be prepared by an attorney if you're going to be paying in advance for a caregiver such as a son or daughter. The other disadvantage is that that is taxable. It's not a gift, it's taxable. You have to do this proper withholdings, and your son or daughter will have to report those payments as income because those are not gifts. And that's the way it has to be income to get around being classified as a gift. Another protection is you can make unlimited transfers to disabled children during your lifetime, and there's no penalty for that. And also, if you were to leave something, and anything you leave in your will to disabled children, Medicaid cannot get a lien against that. They get a lien against possibly against other assets left to other non-disabled children. So someone that's on Social Security disability or can otherwise prove disability. Another way to preserve your assets is to spend down your assets, pay off debts. You can have one automobile. You can buy an automobile. That's not considered an asset, not considered a resource when you apply for Medicaid. Make improvements to your home. What I promised emergency Medicaid planning is for people that have never made any plans for nursing home care. I'll try to explain it to you. I mean, most attorneys probably aren't familiar with it. As I said, this is permitted by Department of Social Services. We've gotten guardianship court orders to do this emergency Medicaid planning with promissory notes, just something so you know what it's called. So this is someone that's just gone into a nursing home and they've never done any planning. And this has to be done with the assistance of an attorney. There's very few attorneys that know how to do it, but it's a very complex calculation. So if you're already in a nursing home and if you have a house or liquid assets, you've never done any planning, it can be set up where you give all of your assets to your children, and they promise, by signing a promissory note, to repay you half the value of those assets. So it's a value of your house and all your other assets. They sign a promissory note, and it's a precise calculation to make monthly payments to you to cover your nursing home bill of $15,000 a month. And how that's calculated depends on what other debts you have. It's a very complex calculation, but you will still qualify for Medicaid. So it basically involves a Medicaid application being completed when you first move into the nursing home, do a promissory note, is done, and you get turned down for Medicaid. That's what you want. You want to get turned down for Medicaid. That gets the clock clicking, gets a clock started for your penalty period, and then when you run out of money, you reapply for Medicaid, and you will, if it's done properly, you will qualify for Medicaid after spending only 1/2 of your assets on a nursing home care. So that's what it's called. If you ever want to look into it, it's called emergency Medicaid planning, and it would have to be done through a guardianship if you do not have a power of attorney with gifting powers, which goes back to why I say you need to have a power of attorney with gifting powers where gifts can be made to your agents or your other family members. If you don't have that, then you need to have the attorney start a guardianship proceeding immediately so that you can take advantage of this emergency Medicaid planning. I know it's a lot to digest, but that's basically, it used to be, this was necessary when the laws changed in 2006. So we've been talking about this since 2006. Before 2006, it was a lot simpler. You could just give away half your assets and you'd still qualify for Medicaid. But since 2006, we had this more complex procedure of using a promissory note. How many people here don't have healthcare proxies or living wills? Okay. So, I mean, this is just like about weekly occurrence in our office. People call up, they want a power of attorney or a will or a healthcare proxy for their family member, but their family member is already incapacitated and can't do that. One change in the new power of attorney law in June is that you can direct someone to sign a power of attorney on your behalf, but you have to have the capacity. So we have to do a judgment call. You know, someone says that their father or mother is able to sign a power of attorney or talk about that power of attorney, but usually it's too late. So then we have to go through the guardianship proceedings either for health care decisions or financial decisions. So basically, the idea behind a healthcare proxy is that you have a constitutional right to refuse medical treatment. That's your right. I'm not talking about euthanasia or anything, but you can refuse medical treatment. You know that you can do that when you have capacity, when you can refuse medical treatment and get checked out of a hospital. If you just want to get out of the hospital and refuse medical treatment, you can do that. But how do you communicate that if you're incapacitated? Well, the New York Court of Appeals and New York Legislature said you have to have a healthcare proxy and a living will to do that. So a healthcare proxy is New York legislation. You can appoint a healthcare agent and an alternate agent to make healthcare decisions for you. But the living will, which we do a combined living will and healthcare proxy, is there particular wishes regarding whether or not, and you can check off in our living will document whether or not you want to be kept alive if you're in a coma, terminal illness, a non-terminal illness like later stages of Alzheimer's, you lose your faculties, and whether or not you want tube feeding or artificial hydration. So your healthcare proxy cannot discontinue tube feeding if everything else is shut down, or artificial hydration unless you specify that in your living will. We also have HIPAA authorizations we put in the living will because oddly enough, your healthcare proxy does not have access to your medical records unless you authorize that. And also a donation of organs. So I have to have 2 witnesses to that. We also notarize them because some states require notarization. There's no national healthcare proxy form. So in 2010, they passed the Family Healthcare Decisions Act, which authorizes people to make healthcare decisions for you, like domestic partners and children. But that's all the more reason to have a healthcare proxy, because there's people, if you don't have a healthcare proxy, there's people out there, like some of your children that you may not have seen for many years, that can make healthcare decisions for you, which may have no idea what your wishes are. So it's all the more, it's a backup, but that's all the more reason to have a healthcare proxy and living will. And also, another thing to keep in mind is the healthcare proxy and living wills are only enforceable in nursing home and hospital settings. So if you're going home under hospice care so that the EMTs don't revive you, you have to sign, or your doctor has to sign, a medical order for life-sustaining treatment if you don't want to be revived if you're at home under hospice care. So you have your doctor sign a medical order for life-sustaining treatment, or you had your healthcare agent authorize that, just like a DNR. A DNR is signed by your doctor, not by your healthcare proxy. A DNR is if you want to be revived if your heartbeat or your breathing stops.